Professor Collett, Section 4E2 of H.R. 2975 includes a list of exceptions, including one which states the bill does not apply to, quote, insurance or medical assistance coverage of abortion services, close quote. Now, a legal analysis by the Lozier Institute points out that since there's no definition of insurance or medical assistance coverage of abortion services, the bill may invalidate the Hyde Amendment, at least in certain situations. So my question as you read through that is, would you agree with that analysis that that section might invalidate the Hyde Amendment?
Congressman, it's quite possible, given the broad interpretation and the purposes of the bill, that a district court would rule that way.
And what other federal laws and policy riders do you think could be overturned by this legislation? I know you spoke to some, I think, with Ms. Brooks, but what other things would be overturned you're aware of?
Independent of the insurance aspect, I'm sorry, I misunderstood the question initially. I'm concerned that it will overturn things like the ultrasound law, like admitting privileges where there is a strong evidentiary basis, there is in Louisiana, things like requiring physicians to perform abortions. There are some states in which you don't even have to be a licensed medical professional to perform an abortion.
Say that again.
There are some states in this country where you don't even have to be a licensed medical professional to perform an abortion. It will also overturn things. Yes, Congressman.
That's amazing. I didn't realize that.
Yes, Congressman. And so there are also some, it will overturn limitations possibly on the use of RU 486. It will overturn certain informational requirements because abortion is, to my knowledge, the only surgery people, with the possible exception of vasectomies, that people seek out because of poverty, not because of a medical need for that particular surgery. It would overturn numerous other important safety regulations that women are protected by in this instance. And arguably, because of the health exception being undefined in the bill, it's possible that post-viability abortions would become essentially available at all times. Congress has received in the past testimony by abortion providers that they believe that a woman who is psychologically distressed with her pregnancy has a health condition that would justify a post-viability abortion.
And define in layperson's terms post-viability abortion.
Post-viability is an abortion that occurs where the child could safely be delivered and surrendered for adoption. Instead, the abortion provider actually goes forward and terminates that child's life.
And how late in the pregnancy can that occur?
As this committee has already heard, the standard age right now is accepted in the medical community is 23 to 24 weeks, although we do have some cases in which children before that have successfully survived.
Right. And do you know off the top of your head what states don't require licensed medical providers to provide abortion?
Vermont is an example, I believe, Your Honor.
Okay,
I'm sorry, Congressman.
Yeah, we're not
I'm
judges
used to
up
court.
here. Yeah, thank you.